All rise. The Court of Appeal of the State of California, First Appellate District, is now in session. The Honorable Therese Stewart presiding.
Recording in progress.
Good afternoon, everyone. You may be seated. We have a significant calendar in terms of the number of cases this afternoon, and so I'm going to be better than I usually succeed at being in enforcing the time limits. So I'll call the cases in the order in which they'll be heard, and if counsel would state your appearances, that would be great. So the first is People v. Gordon.
Good afternoon, Your Honors. Jim Robick on behalf of Mr. Gordon.
Shannon Chase on behalf of the respondent.
And the second case is People v. Shooter.
Good afternoon, Your Honor. Douglas Foster, appearing on behalf of the appellant Ryan Shooter.
Okay. Right. The third case is Gordon versus Sodexo, Inc.
Good afternoon, Your Honor. Stephen Katz on video on behalf of the appellants.
Say it one more time, a little louder.
Stephen Katz on video on behalf of the appellants.
It's Catherine Riblin on behalf of the respondents? Oh, I'm sorry. Rachel Hallam, sorry. Okay.
Apologies.
And then Procured Net Limited versus Twitter.
Good afternoon, Your Honor. Jonathan Patchen on behalf of the appellants.
And another corporate ISP LLC versus Creely.
I'm J. Edward Martin, self-represented appellant.
Ms. Pinelli is on her way, but hasn't checked in yet.
Okay. Stacy, would you sort of remind me if that's still the case when we get there?
Yes.
And the last case is Luskatov, Lemdormy and Associates versus Ofray.
George Wolf for Ethelred, Virginie Leclerc. John Girardi for respondents.
Okay.
Ms. Pinelli just checked in.
Pardon?
Ms. Pinelli just checked in.
Ms. Pinelli?
Yes.
You're here for another corporate ISP versus Creely?
Correct.
And you are appearing on behalf of the respondent?
Correct.
Okay. All right, we will start with Mr. Patchen. It was a pleasure to hear your argument. The matter is submitted, and we will take on another corporate ISP LLC versus Creely.
And I apologize for whatever I caused on the feedback.
Our microphones.
Ours are turned up too?
I've notified IT.
Say again?
I've notified IT.
Oh, okay, great,
Okay.
thank you. Well, at least we have two counsel in person, so hopefully it will be less of a challenge on the hearing. Okay. Mr. Martin.
Yes.
May it please the court, I'm J. Edward Martin, self-represented appellant. As I read the case law, I believe that a workplace violence restraining order is only appropriate when there is a threat of violence and when that threat is clearly related, has a relationship to a workplace. For example, at the end of the most recent case, the North Coast Village Condominium Association versus Phillips, they remanded it to the trial court because it wasn't clear in what the trial court had said that whether there was violence and whether if there was violence, it was to be carried out at the workplace. Those are the words in Code of Civil Procedure 527.8.
But here the conduct, I'm not sure whether you're focusing on an argument that there weren't threats or an argument that it wasn't related to the workplace. But assuming it's the latter, they were right outside the workplace yelling at the employees who were inside the workplace, not even a door between them.
Yeah, I can describe that moment. The point I wanted to make initially is I think the threat must be identified so that the relationship to the workplace can be understood, that both elements are necessary, and that I wanted to first talk about whether or not there was a threat. And that, I think, is the analysis that this court or any court would need to make looking at workplace violence. As far as the episode at the door, I agree that there was a person inside the door, but I think the record shows there was nothing threatening at all. That's a very well documented, as I tried to point out, case where there was a video from the employee of the company, and the person who is being accused by the company of having said something violent is not one of the respondents in this case, someone who didn't receive a restraining order at all. If you look at the transcript or the video itself, you'll see that the conversation that Ms. Creely was having with the other appellant was having with the co-owner of the business, it was a conversation about making plans to have a public meeting. It's a gross exaggeration by the other side to present, to take that moment, which was a conversation, and use the physical place that people are standing, and then link that to violence which happened later on.
But let's focus on that physical place where people were standing. Because weren't there planter boxes that the company was building that were ultimately destroyed? There were loud arguments, there were threats of physical violence. All of these things took place, for lack of a better characterization, at the contested location, which is immediately outside the front door and adjacent to the warehouse building, the plot that everybody's arguing about. And it's all connected to the businesses, what some considered inappropriate use of that plot that everybody's arguing over.
Yeah, I mean, that's the general description, and that's how the trial court was able to make a judgment. But I think in the particulars, it all falls apart. It's the when you closely look for something which can be considered a threat to be carried out at the workplace, it is not to be found there. The argument had...
Well, it doesn't have to be carried out at the workplace. It has to be, I think as you put it, a relationship to the workplace. And when you look at the definitions in the statute, it talks about what a course of conduct is, and a credible threat is defined as a course of conduct, and course of conduct includes things like stalking people on their way to or from work, bothering employees at home. I mean, in other words, it doesn't have to be physically present as that definition would suggest, and I think that was what North Coast discussed.
Yes, and certainly an episode could have occurred on the parcel which would lead to a workplace violence restraining order. I think that part of the lesson of North Coast Village Condo Association is that wherever a threat is made, it can be relate to a workplace. It can be by phone or something. So I think that I think the case was sort of we have to look at the particulars and not the generalities, because that's a different scenario happening, and different words and actions by the same people in the same place could have led to a workplace violence restraining order. But these words and actions that were spoken and the argument that was had and what was being argued about is not appropriate when you look at the details. That's what I was trying to make.
So if I understand your position right now, you're not necessarily contesting the location of the dispute, whether or not it would be workplace violence, but rather you're contesting the substance of what happened, saying that those particulars were not threatening at all or in a workplace context?
I wanted to briefly make that point and then move on to describing the fact that this case, I mean, that this area, that the threats, if they are perceived as threats, relate to a very distinct area, which the record shows is difficult to see as a workplace.
Thank you.
Certainly by the time the boss showed up, I think you wouldn't disagree that, he was actually physically attacked, right?
But that was entirely lawful violence and self-defense. He was the first man who was aggressive there. And when Ms. Creely struck him back, it was immediately after she was struck by him. Her words, which were the most threatening words she uttered, which were highlighted in the trial court, were spoken immediately after. It was definitely a statement of her right to defend herself.
You know, one problem that I'm having relating to this argument about no threats is, if you're going to argue something that's basically, look, the evidence doesn't support the trial court's decision, you have to give a balanced description of the factual record in the brief. And that wasn't done here. And so it's, you know, we don't usually consider arguments like this if the lawyer or the pro per who's treated the same way, which is in compliance with the rules, if you're going to make that kind of argument that there isn't evidence to support something like a threat, you have to give a full and balanced description of the relevant facts.
Yes, and I'm sorry that I ran out of my time and my brief was so short. But I think it included the essentials. I think the essential is the parcel happens to be next door to the business and a neighboring thing, not at all the workplace. And I put in the words which were highlighted in court as the only thing possible that could be seen as a threat. And then I pointed out that the case law, it just is not going to support that in any way. I believe that my reply brief did a better job, and I certainly would have welcomed if the other side had wanted to write an additional response, and I'm happy to answer questions here.
Yeah, you're out of time, but you did reserve some rebuttal, and I'll let you have some rebuttal, but now we should hear from your opponent, Ms. Pinelli.
Okay.
Good afternoon, Your Honors. May it please the court. I want to attempt to try and respond to, I think, what appellant was trying to argue, which is that we should be looking at the specific words and conduct of the threats, and they must be related to the workplace. I don't agree that that is what the underlying statute says, and I don't agree that that is what the case law says. And I want to keep this as simple as possible, but as you probably know, the case law and statute is pretty sparse as to this issue. The statute in question is the California Code of Civil Procedure, Section 527.8. It says that it allows for a restraining order when the violence or credible threat of violence can reasonably be construed to be carried out at the workplace. It doesn't say anywhere in the statute that the threat needs to be related to the workplace, but it does say that either it needs to be at the workplace or reasonably be construed to be carried out at the workplace. This phrase, reasonably be construed to be carried out at the workplace, leaves open it basically allows a restraining order to be issued even if the threats or conduct did not happen at the workplace. And on top of that, as Your Honors mentioned, in the statute itself, it states that the employee can be protected. It allows for a restraining order when an employee is followed to and from the place of work or followed during hours of employment. That plainly allows for a restraining order even when the harassment violence does not happen within the confines of a workplace building. The statute itself that governs these actions is just not limited in the way Mr. Martin wants it to be. There's no definition of workplace in the statute. Other words in terms of arts are defined, such as course of conduct and credible threat of violence. If the legislature wanted to define workplace, it would have, and it didn't. It makes sense and it is logical, as workplace nowadays is versatile and it means something different depending on who you are and where you work. Property issues aside, And as you can see, there are property underlying and overlapping property issues of this case. If we're going by a strict definition of workplace, as in the four corners of a building, as Your Honors mentioned, some incidents happen within the confines of respondent's warehouse, namely the harassment of Alejandro Menendez, which he testified to, and it's supported in the record. There was also a threat of
He
arson.
felt like he was not able to leave,
Correct.
and he testified to that. Can you say any more about counsel's argument that there weren't any threats? I didn't understand the opening brief to be arguing that, but maybe you did.
Are you saying Mr. Martin was saying there are no threats?
Right.
Well, the record doesn't support that. Mr. Menendez testified that he felt threatened, he felt confined. He was also being called derogatory names. He was being videotaped. So he very much felt threatened, and that happened in the four corners of the building, if we're going to go by a strict definition of workplace. There was also, the record supports, there was a threat of arson about 5.5 feet away from plaintiff's warehouse. And so if there was a fire, surely plaintiffs would fear the fire would spread to the warehouse. Again, if we're going by a strict definition of workplace, that falls under fear of the threat happening at the workplace. I'll keep it brief. Like I said, Monkeybrains contends that not only was this the correct kind of case to file and from which to obtain a restraining order, it applied for protection of multiple employees from multiple individuals. And I do want to make one point on that. I think it is important to highlight the purpose of the restraining order filing, because it goes to the kind of restraining order case that was appropriate and the correct remedy to seek. The sole purpose of Monkeybrains' filing of their petition for workplace violence restraining orders was to protect multiple employees and their workspace from unlawful activity and harassment that was going on by members of Friends of the Mission Greenway, specifically Mr. Martin, appellant, and his wife, Elizabeth Creely. Out of the options of the kinds of restraining orders that Monkeybrains could have filed, this was the only kind of restraining order they could have filed to protect multiple employees. Otherwise, they would have to go individually and file civil harassment claims. It doesn't make sense because they felt that their workplace was threatened and multiple employees were threatened. So I do want to make it clear that Monkeybrains has never conceded that Parcel 36 was not their workplace. From the beginning, they've operated like it has. They believed from the beginning that they had a prescriptive easement based off of years of operations on that specific piece of land. But even if they did not believe that, the workplace violence statute and case law, specifically North Coast Village versus Phillips, allows them to seek and obtain restraining orders based on incidents occurring right outside their warehouse. For the foregoing reasons, I think that the court should uphold the trial court's decision. Thank you.
Thank you, Ms. Pinelli. Mr. Martin, briefly.
Yes, to respond to some of that. The non-ownership of the property is absolutely established. I submitted a letter from San Francisco Commission called the San Francisco Board of Appeal. It's the Board of Permit Appeal. I don't imagine that's in question, and that letter establishes both that they don't own it, also that they were unwilling to convince them or the Department of Planning that they, on the Department of Building Inspection, that they have a prescriptive easement for any use. So if there is no use possible or permitted by this, they just have to think of this lot as some other neighboring piece of property that they have no connection to. And I think that all they have managed to do.
Are you now speaking the lot that you and your fellow
Yeah. Yes.
protesters or whatever you want to call yourselves were on?
Yes.
Not the lot that Monkeybrains business is on.
No, and the building goes right up to the property, like other buildings in San Francisco, right up to the property line.
But it's the same parcel that the planter boxes were on.
Yes, yes. And the idea of them talking about a group, I think, is really out of whack. I think that you can't get a restraining order against a group. I really think that that is not an appropriate question to be talking about. In the, and that's in City of Los Angeles, I believe. They talk about particular words like name calling. That was not said by me or Ms. Creely. The name she quoted said against Mr. Menendez was said by a third person who didn't receive a restraining order. And the accusation that I used the word fire, I have to say, I didn't get to cross-examine and make clear in court what my intent was when I was saying that. But I think that if you just look, if you were to perceive it as a threat, you would have to realize it's absolutely local. I was talking about the box we were working on, the argument was on this patch of this parcel of land, about this parcel of land. It's for the business that is next door to think that it has some claim on it is imaginary, and it's worse than that. And their justification for using it does not support what we were arguing about that night. There was a vehicle parked there, which we did not argue about. The building of digging of a trench and to plan to fill it with cement is only described in the brief as a matter of beautification. Certainly not a thing that's connected to their business, which is providing low-cost internet. There's nothing in the record that shows we have an objection to their business, objection to the owners of the business as people, that we had stalking keeps being mentioned. There is no evidence of that. Ms. Creely testified it was the first time she'd ever spoken to the co-owners of the business. It was only the second time I had ever spoken to those people. This was a minor argument on a piece of property they don't own next door to them. It has to be considered a weird sort of, I don't think it can be seen as, we were not arguing about what their business does. We were not, and what they were doing that we were arguing about is really not connected to their business.
Well, if I stand on another piece of property and point a gun at an employee on that property, and it has nothing to do with anything that happened at the workplace, are you saying that's not actionable? That's not something that a restraining order can address?
Yeah, a restraining order could get that, but a workplace violence restraining order, it would have to be a threat that's going to be carried out at the workplace. Even in some cases where, I mean, if it's, that is the distinction. And I do think that on these facts, there is no threat here that would lead to any restraining whatsoever, restraining order of any kind. But the relationship to a workplace, the threat to be carried out at a workplace, that is not quoted. It's not quoted in the respondent's answering brief, and all I can do is point to the words that they put in their exhibits, and they are just general words like, you know, I mean, they're not about, they can't be seen as something that's going to happen in that company's workplace. And the effort for them to identify this stretch next to them as a workplace is based on they've newly bought the building, they want to park there, people have parked there around, well, fine, but they're locking it and making it exclusively their own. She mentioned harassment. I really think that the discussion with Mr. In the doorway had no elements of harassment from me or Ms. Creely. It may have had some from the third person who didn't receive a restraining order. And I think that you can see from the quote or from watching the video that that's not there. And if you read the description that was presented by Mr. Menendez, it doesn't contain a threat. It says that I glared at him. Well, he doesn't know I was glaring at him or somebody else, and certainly a glare is not a threat of future violence at a workplace. None of us entered into that, like climbed up on the his loading dock. We just stood there and talked to him.
Okay, I have to stop you because we still have another case.
Okay, yes.
But I appreciate the vigor with which you argued, and Ms. Pinelli, your argument as well. And we'll take the matter under submission.
Thank you.
And the next case on our calendar and last case for today is Luskatov, Landormi and Associates versus Ofret.
May it please the court.
Mr. Wolf.
Thank you. I would like to address the issues in the focus letter and reserve about 5 minutes for rebuttal. I would also like to hope we can discuss some of the other important issues in this case, which I think need to be resolved or decided by this court, regardless of whether or not there's a mootness issue. I don't think there is a mootness issue. And that is the solicitation by an attorney in the hospital of a gravely injured woman who has 8 surgeries, and the failure to account to 35 joint clients for $15 million in settlement proceedings. No settlement, no accounting ever to those people. And the theft of almost $500,000 from the trust account without the consent of the clients.
Let me just interrupt you. I'd like to ask you about the mootness issue because